good morning, and good afternoon to in-house counsel from all across North America. Welcome to In-House Connect. My name is Shai Mahani. I am the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your breakfast time or your lunchtime with us, and of course, special thanks to our sponsor and presenter today, Stacey Kalamaras of the Kalamaras Law Office, for putting together this fantastic presentation on trademark essentials for in-house counsel. For those of you who are here for the first time, let me give you a quick bit of background on In-House Connect. In-House Connect started 11 years ago as a New York City-based meetup group for in-house counsel. Every month, In-House Connect would organize free CLE classes, which were hosted by different law firms, which were then followed by cocktail networking receptions. And every 6 months, we would organize fun and festive networking mixers. Over the years, we've helped thousands of in-house counsel connect with peers and outside counsel alike. The group was humming along, and then of course, COVID hit. We couldn't meet in person, so we went online, which has been a fantastic transition. We've been able to attract a much larger audience of in-house counsel from coast to coast, and we've been able to facilitate way more networking and relationship building. And of course, we've been able to feature high caliber speakers like the one we have today, who I'm going to introduce in just a few moments. This is our 16th event of the year so far, which is definitely a new record. Today's event, it's a fantastic event. I've been looking forward to this event for a long time. It is Trademark Essentials for In-House Counsel. Today's presenter is Stacey Kalamaras. Stacey is the founding partner of the Kalamaras Law Office and is a seasoned trademark, copyright, and advertising lawyer with a combination of big law, in-house, and prior business management experience. Stacey has extensive experience managing large global trademark portfolios in more than 150 countries for clients in diverse industries. Her firm's focus is creatively assisting small and medium-sized businesses navigate the legal landscape to create distinctive brands and differentiate their businesses in an ever-changing marketplace. Stacey regularly counsels clients on the clearance and adoption of new trademarks, develops strategic protection and enforcement programs through her extensive experience with trademark opposition/cancellation proceedings and anti-counterfeiting strategies, and grows portfolios by conducting IP due diligence matters. In addition, she's well-versed in drafting and negotiating licensing and other IP/advertising agreements as necessary to protect, enforce, and commercialize brands. In February 2020, Stacey realized a long-awaited passion project and launched Trademarkabilities, an online trademark academy for lawyers, with a single mission: to prepare lawyers to become confident and effective trademark practitioners before the USPTO and be practice-ready to help their clients. Learn more about Trademarkabilities towards the end of the presentation, so stay tuned. And just frankly, we're so fortunate to have Stacey on with us today. She is a super experienced trademark lawyer, obviously, as I just mentioned. I'm going to share links to her social, so be sure to follow her. She posts great material. And without further ado, I'm going to turn things over to Stacey so she can help teach us how to manage the most common trademark issues for in-house counsel.
Thank you so much, Shai, for that wonderful introduction. I am absolutely thrilled to be here with you today. I can't thank you enough for inviting me today to speak with you. I understand that your time is precious. I myself have been in-house and worked in-house. And this presentation is going to be a little bit longer than an hour. For those of you that do have to jump off at the hour, we will try to get through the majority of the trademark portion of the presentation. So I understand if you do have to jump off, and there will be a recording available, so perhaps you can circle back. But please feel free to drop any questions that you have at any time into the chat. And I'm happy to take as many questions as we have time for at the end of the presentation. We will allow about 15-20 minutes for questions. So with that, let's get started. Shai has already introduced me to you. The most important thing about my background that I wish to share with you is that I'm a second career lawyer. I spent my first career in marketing and advertising. I worked for about a dozen years for various multinational corporations on the business side. As a line manager, I was a brand manager and marketing director, and I also worked agency side, working with clients, trying to build up their brands. And then in my mid-30s, I transitioned, left my career, and went to law school full-time. People ask me all the time why I made that decision. I wanted to be a lawyer from a very, very young age, but I had no idea what IP law was. And it was when I was working in my role as a marketer that I was working with amazing in-house counsel, and I discovered the wonderful, wacky world of IP. So I'm really grateful for that experience. I've also been privileged to educate now over 5,000 entrepreneurs and attorneys. The majority of those are attorneys on more than 4 continents on various trademark and IP topics since founding my law firm here in Chicago in 2018. And as Shai mentioned, in 2020, I founded Trademarkabilities, which is an online trademark training academy specifically for lawyers, which focuses more on the practical aspects of education, which I think we can all agree we need a lot more of in our industry. So I want to get started talking about trademarks. We're going to devote the majority of the presentation to trademarks. I want to end a little bit with some copyright issues that affect brand protection that you may have encountered a little bit in your role at your company. So before we start talking about trademarks, I think we just have to back up a little bit and talk about what intellectual property is. Well, intellectual property encompasses all of these disciplines. It's frequently, IP overall is patent protection, it's copyright protection, it's trademark and trade dress, and it's trade secret. It's all of those disciplines. And how IP is important to any business, whether it's your business, whether it's me counseling my clients as outside counsel, is you need a strong foundation, and that's the IP, to build a strong house. That's the business. And it's often reported that IP directly correlates to the bottom line when a business, any company is sold. And it's reported that that can account for up to 80% of the value. Now, this varies from business to business. If real property is involved, obviously the real property, any tangential property is worth a lot, but it's the IP, that intellectual property that really can be worth a lot. I want to show you really what I mean by that with some concrete examples. I'm going to do that in just a minute, but first, let's talk about what a trademark is. The legal definition is a trademark is any word, phrase, symbol, logo, or a combination of any of those that is used by a company or an individual to identify the source of its goods. A trademark is a source identifier. So it identifies the source of goods or services in the marketplace, and it distinguishes them from its competitors. Now, business names registered at the Secretary of State or domain names that you buy on GoDaddy or any other registrar, they're not necessarily trademarks. They can function as trademarks, but just because you purchase one, that doesn't mean you own a trademark. However, herein lies the rub. Just by purchasing one, you could be infringing on third-party trademark rights if you don't properly do a search. We're going to talk a little bit about that. So what is a trademark? What types of things in the marketplace are trademarks? Well, you have word marks, brand names like Nike. It's a very famous mark. You have stylized marks, script marks, like the famous Coca-Cola script mark. That's stylization on its own. If any of you are golfers, the Titleist script mark is a type of trademark. It's a portfolio I used to work on. What else? Slogans. Just do it. Another very, very famous trademark. Any advertising slogans. Logos. The Nike swoosh, the McDonald's golden arches. That's another type of trademark. I have the NBC logo here. Of course, this is a logo design, but I have it here to remind me to tell you that sounds can be trademarks. When you hear the NBC chime, that do, 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 you know you're watching NBC. You can't possibly be watching another network. How do you know that? Because it's a trademark. Only NBC can have that chime. The MGM roar of the lion, that's another sound trademark. Play-Doh, why do I have a can of Play-Doh here? Scents can be registered as trademarks, provided they're non-functional. What does that mean? Perfume scents can't be registered, but I bet you, just because I have that can of Play-Doh right there, I bet a lot of you are imagining the scent of Play-Doh right now. It's iconic. That's a trademark. Scents can be registered as trademarks. The Tiffany blue box. The Tiffany blue box. Every girl's best friend. That robin's egg blue color, that's a registered trademark. It's a very valuable trademark that Tiffany owns. I'm going to explain that, why it's so valuable in just a few minutes. Excuse me. And lastly, the shape of the Coca-Cola bottle. That's what we call a trade dress type of trademark. That shape of the Coca-Cola bottle, if you did not see Coca-Cola on it, you would know that Coca-Cola owns that trademark. Do you see how many different types of trademarks there are? So, Shai, if you could put up the first poll question, I think it's appropriate at this point in time, now that you sort of know all of the different types of trademarks there are, does your company own any registered trademarks? Yep, I'm not surprised. They do, clearly, because there's so many different kinds of trademarks. We'll talk about what the purpose of trademarks are. So they're a shorthand way for consumers to identify products and services. Think about it, especially now that online shopping is so pervasive. Whether you're doing your grocery store shopping online or whether you're buying a lot of your products on Amazon, you don't want to say to your partner or your spouse, or, if your teenage child is doing the shopping in your family, you don't want to say, can you make sure that you put in your shopping cart that oat cereal that we really like, the round one with the hole in the middle that comes in the yellow box. It's so much easier just to say Cheerios, right? It really is, trademarks really are a shorthand way for you to communicate exactly what it is that you want and for you to know that you're getting what you want. It's a marketing communications vehicle. It communicates the brand promise. Think of it this way. No matter what you think of McDonald's, and there's no judgment here, right? But no matter where you are in the world, whether you're in a city in the United States or whether you're in a city in your travels in a foreign country, no matter where you are in the world, you know that if you walk into a McDonald's restaurant, you're going to get a fast, delicious, perhaps in air quotes, depending on what McDonald's means to you, reasonably priced hamburger, fries, and a drink. It's going to be consistent is the idea. That's what it means. But what about FedEx? If you absolutely positively had to get a package to someone by 10 a.m. tomorrow, would you go to the United States Post Office? Highly doubtful. Why? Because most people don't trust the United States Post Office. But you likely would choose FedEx, you might choose UPS, you might choose DHL. But the point is that for many, many years, FedEx's marketing slogan was, if it absolutely positively has to be there by 10 a.m. And that's what their trademark means. It means service. It means overnight service. It means by tomorrow morning. And that's likely why you would choose it. That's what trademarks, that's what branding is all about. And that's why it takes a lot of money and a lot of investment to build up a valuable trademark. It's important to note, however, that trademark rights are territorial in nature. They're territorial in nature both in terms of the jurisdiction and in terms of the scope of protection, meaning the goods and services for which they're used. Of course, with every aspect of law, there are exceptions, But what I mean by that is that once you own a trademark, you don't own it for everything. Case in point, we have Ace Hardware stores, which I believe exists outside of the Midwest, but is a chain of hardware stores that is very, very prevalent in the Midwest where I live. And then there's also Ace elastic bandages that I think everyone is familiar with, that is sort of the go-to if, you have a sprained ankle or a sprained wrist. The point is that you would never walk into an Ace Hardware store and ask the people in the little red vests what aisle the Ace bandages are in. They would look at you like you're crazy. And conversely, you'd never walk into a Walgreens or a CVS and ask them in what aisle you can find a screwdriver. Do you see? So there's no likelihood of consumer confusion, and that's why both of those trademarks can coexist. The same thing with Delta. Delta Airlines and Delta Faucets, both of those Delta marks coexist. And Dove, there's Dove chocolates. I have a picture here of a Dove ice cream bar. It's a line extension of the same brand name, and Dove Beauty Bar. There's very little likelihood of confusion between those brands. This means that trademarks are a valuable IP asset. They're actually the most valuable IP asset of that pyramid for many reasons. And it's because that trademarks can last for as long as there is use. They do have a set period, but they can be renewed indefinitely so long as there's use. That's not true with patents, and it's not true with copyrights. And this is why they are the most sought after IP asset in M&A transactions. So let's just look at the process on a macro level. We're going to look at the USPTO process in a little bit more detail in a few slides. But we start with searching. That happens long before the application process. And then there's an application process, registration, maintenance, renewal, and enforcement, which is on an ongoing basis. To search and secure a registration, depending on what size firm and who you use, you're going to spend somewhere between $3,000 and $10,000 per mark. And that's a function of what type of searching you do, what type of issues you encounter during prosecution. But the government fees are very, very low. They're between $250 and $350 per class. For maintenance and renewal, no matter what size firm you use, you'd be hard pressed to spend $1,000. And most firms are going to charge you less per mark. And the government fees are $525 or less per class per mark. But enforcement is a different issue. Now, again, it's not expensive when you compare it to patent enforcement, which is, of course, in the millions. I mean, that's just a foregone conclusion. But trademark enforcement is going to vary on the jurisdiction, whether you're at the USPTO or whether you're in state or federal court, and whether you're trying to settle or whether you're, have to take something all the way to the bitter end. It's going to be somewhere in the $10,000 to $30,000 range for a settlement, all the way up to $400,000 plus if you have to litigate something to the end. Now, trademark infringement, as we were just sort of talking about with the, Dove candy bars, Dove beauty bars, Ace Hardware, and Ace bandages, trademark infringement is a very fact-intensive analysis, but it's really defined on a legal basis if the mark is the same or similar for the identical or related goods and services. There's 13 legal factors that we look at. When you're at the USPTO is limited jurisdiction. They're only concerned with issues of registrability. Federal courts are more concerned with a more holistic view concerning issues of use. They look at packaging. They look at, product placement if the products are sold in the grocery store. And so I always consider the USPTO to be more of kind of a Disneyland perspective, right? Because they're really dealing with more of a make-believe perspective, because they're just dealing with what's on paper, the application and or the registration. And federal courts are more concerned with really what consumers are actually thinking instead of the hypothetical what they could be thinking. And there are also state court trademark issues. Every state has a trademark statute. It's not the ideal place to litigate, but there are other issues that come up in state court, like unfair competition and consumer protection issues as well. Now, the metaverse is sort of the new hot thing. Facebook now has officially rebranded as Meta. Nike bought a virtual shoe company for a boatload of money, and even Olive Garden and some of your favorite brands now are launching NFTs and launching in the metaverse. I have no idea what this means. It was just reported last week that one of the largest NFT holdings, their application was refused at the USPTO for lack of failure to provide adequate use. Whatever happens with Web 3.0 and the metaverse, I can guarantee you one thing: the standards of proving use for trademarks is not going to change. So while the law is always slow to catch up to technology, trademarks are valuable because they are tied to use. So whatever these companies are doing in the metaverse, they better be prepared to prove their use properly, or there's going to be a whole bunch of applications that are going to go abandoned. That much I know for sure. I don't need a crystal ball for that. However, it is expected and forecasted that this is going to be a $280 billion with a B industry just in the next few years. And as of last night, because I just updated this figure, 380 trademark applications have been filed just containing the initials NFT, which basically suggests to me that there's going to be a whole bunch of dilution and saturation for any mark that contains this new technology. As you may be able to suspect, I'm not a big fan of this area. I don't work in this area. I don't like this area. I don't believe it is the next big thing because I think there's going to be a huge problem with use, but that's a story for another time. Here's what I really want to talk about. I alluded to this at the beginning: the value of trademarks. They are incredibly valuable. Here's 3 examples of why. Barney's. I think everybody has heard of Barney's, luxury retailer in New York. You may or may not know they went bankrupt in 2019. But here's what happened. They were sold, the IP was sold in bankruptcy court in October 2019 for $270 million. They were closed, they were defunct, but somebody bought the IP. They bought the name, they bought the rights to the trademark. What does that tell you? That tells you that the name was valuable. Now, what happened a lot with brick and mortar stores like Toys R Us, iconic toy retailer, that's another brand that was also sold in bankruptcy. For brick and mortar stores that had really strong trademark following and loyal consumer followings, those brands were sold for online plays. I don't actually know what came of Barney's. Obviously, this was before the pandemic. Barney's, very expensive brand. Our world is very different now, 2.5 years later, but someone actually paid $270 million for the brand. It takes a huge amount of time and effort to build up a brand to that perspective. But that's where the value is in a trademark, if it's done properly. Remember, we're talking about the little Tiffany blue box? Well, in November 2019, a month after the Barney's deal, Louis Vuitton's parent company bought Tiffany & Company for $16.2 billion. It's the largest deal ever in the luxury sector. Now, when these negotiations were originally going on, I remember the negotiations were in the high 13-something billion to low 14-something billion. And you may be thinking, that's just insane. What's a couple $1 billion among friends? The point is that Tiffany knew its value. How did they know their value? They knew the value of their brands. That's what shot the price up to the 16.2 billion. There are actually companies that value that do valuation of companies based primarily on their IP. And I have no doubt there were many, many companies involved in valuing the Tiffany deal that fetched them this amazing price. Ford, I love this example. Those of you who remember the Great Recession and the bailout from the government of Detroit automakers, Ford didn't take any of that money from the government. You know why? They securitized their IP for a $23.5 billion line of credit. That's how they were able to see themselves through the financial crisis. And in 2012, they repaid that debt. So this iconic logo is what saved Ford through the Great Recession. They leveraged their trademark portfolio. I mean, not just this logo, their entire portfolio. And they got a $23.5 billion line of credit by securitizing their trademark portfolio and paid it back 3 or 4 years later. It's quite remarkable, and never took a red cent from the government. Amazing, amazing, amazing success story for Ford. Okay, I want to move on and talk about the importance of a US trademark registration. I'm talking about at the federal level. Trademark registrations, I hope, as I've demonstrated, are very valuable IP assets. I've already mentioned that they can last indefinitely so long as they are used in commerce. But do you need one? Well, that depends. They're required to take down social media infringers. They're required if you have a counterfeit issue, if you want to combat those counterfeiters. And they're required if you have an Amazon seller store. They're extremely helpful if you're seeking an investment, if you're a startup or have a new business, if you want to send a cease and desist letter to an infringer or sue an infringer. And they increase the value of any license agreement. You can get more if you have a trademark registration. What is the role of trademark counsel, outside trademark counsel, even inside trademark counsel? Some companies are so large. I've served in that role for 2 large multinational corporations. What do people like me do who focus specifically on trademark and brand protection? Well, we serve a role as searching marks, where we counsel clients on the adoption and selection of new marks. We help prosecute applications. That means that we file trademark applications at the USPTO and in other countries. We serve as the expert and add value to our clients, whether those are external clients or internal clients, throughout the entire application process, whether that's at the USPTO or liaising with foreign counsel on their country's process. We guide our clients regarding the proper use of trademarks. We review websites, website use, packaging use, if there are goods sold. We help enforce the trademarks. We can watch trademarks. We can advise on potential infringements. We can send cease and desist letters when it's advisable. We can represent clients before the Trademark Trial and Appeal Board. That's the litigation arm of the USPTO. There are other arbitration forums. There's also federal court. There could be state court involved. It doesn't come up very often. There's also the commercialization of the trademark. Could be licensing and other agreements that involve the brand. And transferring assets. Very, very important for any business, whether it's buying another company, whether it's selling a company, whether it's perhaps deciding to sell maybe a business unit. There's lots of ways where transferring assets becomes important. Okay, the USPTO process. So this is really important to understand if you're filing any applications or if you're working with outside counsel on any applications at the USPTO. I think it's so critical to understand how it works. So before anything's done at the USPTO, there should be some sort of search happening. We're going to talk about searches in just a minute, but typically we search the mark that the client intends to use. And whether you're handling this internally or you're outsourcing this, the same process should happen. Before you file, do a search. If your mark is currently in use, right, this is the top line. There's just one little difference you see here, this purple bubble, which I'll explain, between a use-based application and an intent to use based application. So after the search, then we prepare the application and we file it. Between filing and examination, nothing happens. Right now, because of the pandemic, there's an enormous backlog at the USPTO. Pre-pandemic, this time lapse was about 3 to 4 months between filing and an examiner being assigned. Right now, the backlog is about 6 to 9 months. It's really significant. However, for use-based applications, this entire process between filing and registration, between the gray bubble and the green bubble, provided you have no issues, hasn't changed. It still takes about 12 months to secure a registration, provided there are no issues, which is why the search is so important. So no change. It's just this process here between gray and yellow has gotten a little bit longer. So your mark is examined by an examiner. And if there are problems, you will receive an office action, which is a letter from the USPTO, which basically outlines the deficiencies in your application. They can be administrative deficiencies, and they can be serious substantive refusals of registration. If nothing is, if everything's okay with your application during examination, and or if you're able to correct all of the deficiencies, then your application proceeds to publication. Publication is the part of the process that I like to call the speak now or forever hold your peace part of the process, right? So your application is published in the Trademark Official Gazette. It's a public document. It used to actually be a publication printed. It is no longer. It is completely online. Anyone can search it. And it is the part of the process where any third party can raise an objection. And that's where they would file basically a lawsuit at the USPTO, the administrative arm of the USPTO called the Trademark Trial and Appeal Board, whereby they would claim that they would be harmed if your registration were allowed to proceed. That is where things can get expensive. Again, why we search, and where your application can get tied up. It's a 30-day publication period. And then if all goes well and no oppositions to your application are filed, your registration should issue about 8 weeks after the publication period closes. Then your certificate of registration issues, and only then, when you receive the certificate of registration, do you own an issued registration. So when I was talking here about the importance of a U.S. trademark registration, that's when you have your trademark registration. Prior to that, you have a pending application and the common law rights that go with that. But only when you receive this document from the USPTO do you have an issued registration. There are ongoing maintenance and renewal documents that you have to file during the first 10-year period after your registration issues. Between the 5th and 6th years, you have to file documents, and between the 9th and 10th years, and then every 10 years thereafter. So you don't just stick this in a drawer and forget about it. You must file documents, but as long as you're using your mark, this is very routine and very simple. But again, the search is so important. I can't underscore it enough because it really can make this process work seamlessly or not. Now, intent to use is a basis where maybe you're developing your product or service, it's in R&D, and that's okay, so long as it's forthcoming and you have what we say under the law is a bona fide intent. Again, you should search, almost more critical when you're filing under intent to use. The process is the same. You file, it's examined, it's published. If everything is the same, you see it doesn't proceed to registration. You get something that's called a notice of allowance. That's because only marks that are used in interstate commerce in connection with the goods or services in the application are eligible for registration. So there's this interim step here. After publication, the office says, okay, great, everything's fine, no one objected, and now you receive a notice of allowance. It's basically like an approval, and now you have 36 months from the time you receive the notice of allowance to file what we call a statement of use. Now, even though you have 36 months, every 6 months, you must take action and basically raise your hand and say, yes, please don't forget about me. Don't lose my place in line. We are still interested. You can file up to 5 extensions of time before you must file your statement of use. And if you don't, your application is abandoned. So this process can take a long time. That's completely dependent upon you and your company and how quickly you are developing the goods and or services. But the importance of filing your intent to use application is it establishes your priority, because the USPTO examines applications only in the order in which it receives them. Even if you have prior use, the USPTO doesn't care. It just looks at the order in which they're received. And if someone has prior use, then they must go to the litigation arm of the USPTO to litigate that issue, because the examiners only care about the filing date. And that's why the intent to use basis is such an important basis. It's only been around for about 20 years or so. It's a very important strategic advantage. I want to talk about strength of trademarks, because not all trademarks are created equal. And so many small companies, especially so many marketing agencies, get this wrong. And it's so important for you as the steward of your company to understand where the hierarchy of trademarks fall. So the most enforceable trademarks, the strongest trademarks, are fanciful trademarks. Very few companies are going to have the marketing budget to back these up. These are coined words. These are made up words. These are words that never existed in the English language before these companies invented them. This takes hundreds of millions of dollars, if not billions of dollars of advertising budget to create the connection between the consumer's mind and the goods and services. This is for, this is the 1% of companies out there, maybe less than 1%. I don't advise this route for very many clients, because most clients can't afford the marketing spend that goes with it. Arbitrary, however, is the second level of strength. And these are words that exist in the English language, but they're turned on their head. For instance, Apple is one of the most famous examples of arbitrary trademarks. No one can own Apple for an apple, or Apple even for fruit. Don't get me started on the fact that Apple Incorporated thinks they own Apple for all fruit. That's an enforcement strategy choice. But when you turn Apple on its head for computer goods, it becomes a very, very strong trademark. And in fact, has become a very famous trademark and a highly enforceable trademark. The same thing with Camel cigarettes. Cigarettes are very much on, the social pariah these days, but a very strong trademark. And Shell Energy, right? Shell gasoline. I mean, Shell is, no one can own Shell for seashells, but when you take a mark like Shell and turn it on its head for gasoline, it becomes a very, very strong mark. At the bottom of the strength diagram. And the last category of marks that are eligible for registration on the principal register are suggestive marks. These are marks that are aspirational. They evoke something in the consumer's mind. What do I mean by that? Copper tone is my favorite example. I know it's not in vogue anymore to lay out in the sun and worship the sun, but I grew up in the 70s and early 80s. That's all we did. So let's think about it. What is the purpose of sunscreen today? It's to block out the harmful rays. Even in the 70s and 80s, the purpose of suntan lotion, as we called it, was to enhance your sun tanning experience. Copper tone, if you applied it, it didn't turn your skin copper toned, because what was that based on? It was based on the coloring of your skin. It was based on your complexion. It was based on how much time you spent sitting out in the sun. It was based on so many things. I was very prone when I was younger to tanning very quickly. My sister would turn lobster red. She, of course, ended up with skin cancer, nothing serious, but she had a lot of growths removed in her 30s and 40s. And it's a result of the fact that we both sat out in the sun and she would turn bright red and she thought she was getting tan and I would get very, very brown. And we used the same products. And so how did that happen? The definition of a descriptive mark right below the dotted line is a mark that describes a quality, characteristic, or feature of the product. Well, copper tone doesn't do that. It doesn't describe what a suntan lotion or sunscreen does. It gives the impression in the consumer's mind of something that they aspire to, something they hope for. That's the difference. It's a very subtle difference. It's a very nuanced difference. And that's the same thing with KitchenAid. KitchenAid is a portmanteau. Jaguar for a car is a very clever, suggestive trademark because a Jaguar is a fast animal. The implication is that it would be a fast car. So those are very clever, suggestive trademarks. When you get below the line, while these are all registered trademarks today, these are terrible, weak brands. If someone were coming to me today and they were just starting out and they had no budget, we couldn't do anything to protect these. Raisin Bran for a cereal that consists of raisin and bran flakes. A terrible name. Why is it terrible? Because it's descriptive. It describes the product. It would end up on the secondary register, which I'm going to describe to you in a minute, and it would cost a fortune to enforce this mark. American Airlines, for an airline that flies in America, same thing. International Business Machines. How did these companies get these marks? Well, it requires something more. Under the law, that's called acquired distinctiveness, and that comes back up here to fanciful. These companies had to spend tons of money, tons of advertising, tons of marketing to be the only ones using these names and knock out everyone else. And that's what I think marketing agencies especially don't understand when they come up with these ridiculously descriptive names, and the clients for which they come up with these names for also don't understand, because I spend the majority of my time counseling clients on how bad their choices are for descriptive names. Obviously, it's always a client's choice, but then invariably a year later, they want to send a cease and desist letter to someone. And the response back is always, well, there's, 50 other people using this mark. And that's the issue. If 50 other people are using it, we can't really shut them down. There is no lawsuit to be had. And so when you've got that situation, it's already run away from you. So you have to be prepared to throw a lot of money at a situation when you choose a really bad descriptive mark. And generic means it's just incapable of protection. It doesn't matter how much money you've thrown at it. If you're familiar with the Booking.com case, even though that was argued on generic grounds, I don't think, and I know it's a Supreme Court case, it really isn't a generic case. It was really argued more on descriptive grounds, and the holding is very, very narrow. The important thing to know about genericness is a mark can become generic due to misuse. And escalator and aspirin, most people don't understand. Both of those were registered trademarks, and they now are generic terms. Both of those marks lost their rights due to misuse. Okay, so we have two registers. We have a principal register for distinctive marks. Those are the ones above the line for fanciful, arbitrary, and suggestive marks. And the supplemental register is our secondary register. That's where descriptive marks live. There can be a benefit to having a supplemental register for a descriptive mark that already isn't pervasive in American language. And you see the benefits here, that you still get to use the circle R, that it can still be searched and cited, but the limitations are significant. The mark doesn't publish. You can't register it with customs to prevent the importation of counterfeit goods. It never becomes incontestable. You still have to prove all the facts in the certificate in any court proceeding, and it cannot be used as the basis for an Amazon brand registry. So how do you use a trademark? Well, a trademark is something special unto itself. You have to use a trademark as a source identifier. Descriptive use is not trademark use. Let me give you an example. Public storage is a registered trademark. I'm sure everyone's familiar with the company. They're all over the nation. That is also a descriptive mark that has acquired distinctiveness. It has that something more. However, if you are also in the warehouse space and you say on your website, again, this is very, very fact specific, but I'm just trying to give you an example. And you say that we offer warehousing services and we make our storage available to the public. That's not infringement of Public Storage's trademark. They will send you a cease and desist letter. This is a hypothetical based on a real example, but it all depends on the use. But descriptive use is not trademark use. Conversely, when you own a trademark, you shouldn't be making descriptive use of your own trademark. Very, very bad idea. Surefire way to lose your own mark. Trademarks should be used exactly as they're registered. The mark has to be exactly the same. If your mark is, Acme, blue, something or other, you can't change the order of those words. If it's a logo design mark, you can't change the logo design mark, and it has to be used only for the applied for goods and services. The most important thing is adjectives are trademarks. They're never nouns, they're never possessive, they're never verbs. And misusing a trademark, again, surefire way to lose it. One of the questions I get most often is, what's the difference between the TM symbol? You see that a lot, right? Up above, like superscript by a trademark versus that circle R symbol. The TM symbol is the symbol that's used when an application is pending or when a company is relying on their common law rights. And the circle R symbol can only be used once you receive that certificate of registration from the USPTO, and only in connection with those goods and services in the registration certificate. Any other use is fraud. And failure, the more important point is failure to use the circle R symbol once your certificate of registration has issued can seriously diminish your ability to collect damages in any infringement proceeding. So it's really important to understand what your mark has registered for and when it has registered. If you're manufacturing goods, you don't have to put the company in debt to throw out packaging flats or anything like that. You should be making decisions to reprint the packages as soon as practical. You also shouldn't be ordering, 5 years worth of product either when you have an application that's pending. Okay, so when should you refer something to outside trademark counsel? Because I know how difficult it is when you're working in-house and managing resources and managing a budget. It's not easy. I think preliminary searches, if you feel comfortable, can certainly be done in-house, but I think full searches and the opinion letters should be outsourced. primarily because the opinion letter is so important, because it can be used as a defense in any trademark infringement action. We have a Supreme Court case now that's a couple years old that proves that the full search in the opinion letter can prove that the client is an innocent infringer, which can go against a finding of willfulness. Complex office action responses can be a huge time suck. They can take sometimes, the better part of a day or even longer if you're not very experienced in handling those. I would certainly outsource those. Would outsource all of the enforcement work and manage the strategy in-house, especially because litigation can be such a time suck. So I would identify a point person and work with very experienced outside counsel on some of those things. Commercializing the brand, again, run all the strategy in-house, but make sure that all of the appropriate clauses, if you don't have a very experienced IP person in-house, that you're appropriately protecting the brand. And then any M&A, due diligence, assignment, security interests, that those are properly being done and protecting your brand. That's some of the things that I would recommend. I want to talk a little bit about why we search, why it's so important. It's so important to make sure that when you choose a mark, when the business comes to you with an idea, because we have common law rights in the US, that it's available for both use and registration. We learn a lot when we do a search. Not only do we learn what the viability is for registration at the USPTO, but we can also learn whether there might be some infringement on the client's part for third-party rights. We can see whether there's, we can get a sense of the indication of the strength of the mark and whether there will be problems prosecuting the application at the USPTO. We can get a sense of the descriptiveness of the mark just from the search, whether the USPTO might require a disclaimer, whether we may need to convert a word mark into a logo plus a word mark. All of this type of intel, believe it or not, comes from a well-executed full search. Changing a brand name many years later, after you've already established a brand following, it's not only expensive, it's also incredibly disruptive to the business team. And so I believe that executing a proper search strategy can really be a beneficial money saver to a business. But it has to be a team effort between the marketing business team and legal, whether you're running searches in-house or in tandem between in-house and outside counsel. There's two types of searches. We do preliminary searches, and these can be sort of dialed up or dialed down, where you take a look at what's going on at the USPTO database. You can also coordinate this with a simple Google search. This is very helpful to narrow down a long list of candidates from the business when they're starting to name, a product line, whether it's an actual product or a new service line. It's not for purposes of clearing a mark. It's for purposes of narrowing down the list of contenders to determine one or more names that are viable to send to a full search. So it's not so much a, yes, this looks good, as it is it's more of a negative search where you determine which marks have problems, serious problems, so you can eliminate those from the list. And then, when I was in-house, I would do about, 20 or 30 of these a day, and it would help me to eliminate, more than half of the names, and then send those back to the business so that they could narrow down the 2 or 3 that they would want to send through full searches. Full searches are more expensive. We pay a vendor to actually run the full search. They tend to run between 300 and 600 pages. They include various common law databases. They're more comprehensive from a USPTO perspective. They include state registries as well. And it's the only way to truly clear a mark. If you're working with outside counsel, that's the only basis upon which you should be receiving an opinion letter. It's technically malpractice to write an opinion letter on anything other than a full availability search. And that's the letter upon which you can rely on if you were ever sued in an infringement proceeding in court. And so those are the differences. This process, by the way, can take many, many months. So it's important to start it early. And it's not easy. I'm here to tell you, it can be very frustrating, and the business can get frustrated. So as an in-house person, it's important to to educate your people so that they understand they can't send you a list of 10 names on a Monday and expect to be launching next week. It doesn't work that way. That's a recipe for disaster. Complex office action responses. As I mentioned earlier, an amendment to an ID, a disclaimer, a substitute specimen, those usually can be handled in-house. They're relatively straightforward. They're not very time consuming. Of course, if you don't feel you have the expertise, an outside counsel partner would always be happy to assist you with those. But the substantive refusals, where it's a real refusal of registration on the basis of likelihood of confusion, or merely descriptiveness refusal, or failure to function, or generic refusal, that can be complex, can be time consuming. It can affect the registrability of your application, and the arguments that you submit will lay the foundation if you ever wanted to appeal the decision of the refusal of registration, because you're basically creating a record for what comes after. And so outside counsel can really be a great resource for you in those instances if you don't have someone inside that's really experienced with handling trademark matters at the USPTO. Fraud. This is such an important issue. I think it's so important to make all in-house counsel aware of this. At the end of last September, I think it was, this decision came down from the USPTO. There's a hyperlink here in the materials so that you can read it. If you're signing any documents before the USPTO, which I don't really think you should be doing, I think your business officers, your VP of marketing, your owner, if it's a small corporation, they should be signing, you shouldn't be signing. But if you choose to sign, be very careful what you sign at the USPTO. In this particular case, just very briefly, the general counsel of this organization, Great Management Group, signed a declaration. All declarations at the USPTO are signed under penalty of perjury. Well, I take that back. He didn't sign. His paralegal signed his name, which is another issue because that's not allowed. You're only allowed to affix your own signature. So that was the first issue in this case. But she signed his name, so that made him liable. But he signed. He didn't even look at the declaration. He didn't understand what he was signing, and it's okay. Whether you're working with someone on documents at the USPTO or whether your business people are, they have to understand what they're signing. And they may not have all of the information to attest to the facts in the declaration, but that's what other people in the company are for. So if your VP of marketing is signing, or if you're at a small company and your owner's signing, it's okay for the owner to ask, the head of engineering or the head of sales or the head of marketing, hey, I wasn't involved in this. Is this true? And so the point is to conduct a, quote, what we call reasonable investigation prior to signing. And that didn't happen in this case. And it resulted in the USPTO lowering the fraud standard from intent to reckless disregard, because there was just so many comedy of errors in this case. It's a great case. It's an important case, but it's important to understand the impact of what happens when you are submitting documents at the USPTO. So I think it's an important case to understand. Support staff, if you have a paralegal, they can prepare anything you want for you, but if you're signing, you have to sign your own name. Support staff can prepare anything, but they have to send it to the person who is actually going to be the signatory. Thank you, everyone, for sticking around. I know we're about 10 minutes past the hour here. So, enforcement strategies. Trademark owners have an affirmative duty to police their marks. That's part of the privilege of owning a trademark. However, make sure you exercise caution before you send off a cease and desist letter. Why? Well, if you don't have the proper foundation to do so, it could lead to a declaratory judgment action being filed against you, the author of the cease and desist letter. I see this all the time, and I post about this all the time on my LinkedIn feed. Most companies' sales forces, or the people who are doing the day-to-day sales for your company, if you're not large enough to actually have an organized sales force, trust me, they'll be the first people to bring to your attention in the legal department that they think something's a little wonky. And that's a great resource. But a best practice is to run that through Trademark Counsel before you take any action, because not all use is trademark use or is infringement. So remember that to initiate a lawsuit, you actually have to have use in that jurisdiction to bring an action. What do I mean by that? Well, the certificate of registration, your trademark registration certificate, gives you presumptive rights to national use. If you're still scaling, that doesn't mean, and you're only operating, let's say, in Washington, Oregon, and California, and someone is infringing your mark in Maryland, you may not have jurisdiction. So what's going to happen if you send a cease and desist letter? They're going to ignore you, probably. And then what? Why send a cease and desist letter if you're not willing to follow up on it? So these are some of the strategies you'd want to discuss with Trademark Counsel and or Trademark Litigation Counsel. And just be very, very careful before you start firing off cease and desist letters. Be very strategic about it. Commercial exploitation of the mark. This is licensing. It's a great way to generate additional revenue for your business. It can increase your brand awareness, and you don't even have to do anything. You don't have to make anything. But you have to, as the trademark owner, control the quality of the mark at all times, or you risk losing your trademark. It's called a naked license. So you want to make sure that the goods and services you're licensing are contemplated by the registration. If they're not, no problem. You can file a new application. So to give you an example, I used to work for the NutraSweet company on the Equal brand when I was in the business world, and our registration was for sweeteners, right? Artificial sweeteners. But we did a licensing deal with Brock's Candy for them to manufacture sugar-free candy that was branded under the Equal brand, right? It was a co-branded product between Brock's and Equal. Well, Equal didn't own a registration for candy. No problem. We just applied for one. But then we licensed the value of the trademark of Equal to Brock's. We didn't have to do anything. Brock's manufactured everything, and it was just an immediate percentage to the Equal bottom line. It's a terrific way to add income to your business. But make sure you always have a trademark attorney review the IP provisions because of this quality control provision. It's a very, very important part of the licensing considerations. Your in-house attorneys, I'm sure, can handle every other aspect of the contract and the deal, but just make sure those licensing provisions, those particular IP provisions, it will not take a long time, less than an hour, I promise you, for a trademark expert to make sure that the licensing agreement is properly phrased. So some other IP promotions, right? You might You might want to run a sweepstakes. You might want to do some sort of a contest online. There's a lot of IP issues that are at play there. Just make sure that you are well versed in that, and if you're not, that you're running that by outside counsel. And a lot of the different social media platforms now have different rules. I see tons of people saying, make sure you like this post or share a photo to be entered into our contest. That is so against almost all of the social media platforms' terms of service. So if you're running promotions like that, please make sure you're reading the platform's sweepstakes and contest rules before you implement something like that. Due diligence, we talked about this a little bit at the top. If you are getting ready to buy a business or sell your own business, particularly with respect to buying a business, you want to make sure that you're checking the trademarks, copyrights, patents, but especially trademarks. You really want to check the owner of record. Does it match who the seller says they are? Are there any gaps in the chain of title? Has the mark been assigned? Should it have been assigned? For domain names in particular, you want to check the registrar information, which has been complicated a little bit by the GDRP because it's really hard to see that information. But we definitely like to check for any pending litigation involving the IP. We like to check the license agreements. Can they be transferred? If they can't, can we terminate them? If they can't be transferred, again, can they be terminated? We really like to check for security interests, like the case with Ford. Are there any unreleased security interests? I mean, remember, with security interests, all of that is taking place with the appropriate state agencies, but we have a notice filing system at the USPTO. So you also want to make sure that the proper documents have been filed at the USPTO. I can't tell you how many deals I've been involved in where years later, a bank that is now defunct has not properly been released at the USPTO, and it is complicated to try to figure out how to undo that, 5, 10, 15 years later. So the other thing I would tell you is if you're involved in any of these deals, don't forget about the USPTO, because we have a notice filing system as well. It doesn't effectuate the security interest. I know you're doing all of that at the UCC, but don't forget about the USPTO if you're dealing with any IP assets. So we talked about this with security interests. We talked about this with the Ford example. Don't forget how valuable your IP is. Banks can take collateral in IP. Make sure that you're drafting an appropriate security interest and make sure it's being released when the debt is paid off. So what types of IP can be transferred? Patents, trademarks, both US and foreign trademarks, Twitter handles, commonly used hashtags, vanity phone numbers. These aren't necessarily trademarks per se. It depends how they're used, but these can and should be transferred with the sale of a company, depending on the terms of use of the various social media platforms. Copyrights, which are creative works of expression, trade secrets, which is confidential know-how, any and all domain names, licensing agreements, R&D agreements, company policies that you have protecting your IP, NDAs, confidentiality agreements, software and databases, distribution lists that you may have, software and IT systems, back office admin processes and procedures, front office sales and marketing processes and procedures, corporate minute books, employee handbooks, list of websites and social media accounts. The point is that when you are selling a company, you have a lot of things to think about when you go to sell your company. Okay, I want to spend just a few minutes talking about copyrights in the realm of brand protection and a couple of examples that I think will highlight some very important issues for you. Let's talk first about what a copyright is. Well, copyright really protects a company's messaging. It protects original works of authorship. Things like literary works, dramatic works, musical works, artistic works. It can include things like architecture, sculpture, choreography, even computer software. Here's the one thing, it doesn't protect ideas. The copyright owner is vested with the legal rights to publish, reproduce, display, and sue to enforce the copyright. The term is generally life of the author plus 70 years. It depends on the type of the copyright, but that is generally how copyright works. Very, very high level overview. So original works are protected the moment they're created. So these slides, for instance, they're my original work of authorship. There's copyright protection in them. I don't have to do anything more. However, if I choose to, I can apply for registration at the Copyright Office if I want added protection. Then there would be public notice of the copyright registration. There would be evidence of the validity of the copyright, and I would have the right to sue for damages. Now, it's not necessary to have a copyright registration. However, a number of years ago, I think it's about 3 or 4 now, the Supreme Court issued a decision in the Fourth Estate case that said if you want to sue, you must have a registration before you file the case. Now, there is a difference between statutory damages and actual damages in a copyright case. Actual damages are so incredibly difficult to prove. They're expensive and really, really hard to get a handle around. So most people go for statutory damages, but herein lies the rub. You have to apply for a copyright registration. You have to file your application during the first 90 days after publication. Meaning, if I didn't apply for a copyright registration within 90 days of today, I would be out of luck. So what is the scope of copyright? So I mentioned that ideas are not subject to copyright protection. Also facts and information. There was a case a few years ago on the Carlton dance. Remember Carlton from the Fresh Prince and his little, happy dance? And the court, I believe it was in the Ninth Circuit, found that it was a routine social dance, and they found it wasn't original choreography. There was a big uproar in that case. There was also the Fortnite case dismissed out of hand because of the Fourth Estate case. They hadn't filed the application before filing that case. About 10, 15 years ago, Bikram, sort of the father of hot yoga, he sued all of his students who had taken classes from him and established similar yoga studios and sort of ripped off his concept and how he taught his yoga sequence. And the court said that yoga is sort of as old as time itself, and the compilation of yoga poses is not an enumerated category in the Copyright Act, and therefore it's not eligible for copyright protection. Now, phone books and recipes have what we call a thin level of protection. You might be laughing at me and saying, seriously, a phone book? But think back to the days when there were phone books. There were 2 major players in the phone book category. And it's the information in the phone book isn't eligible for protection. You've got the information. You've got Stacey Kalamaras, resides at this address in Chicago, Illinois, at this phone number. That's not the information, but it's how the phone book was laid out. Maybe one of the purveyors had the white pages first and then the yellow pages. And what about all the yellow pages ads? Those were kind of laid out with what we call a thin level of protection because there's just a modicum of creativity. Recipes, I get this question a lot with recipes. The ingredients are listed as such, but maybe how you tell people how to make the recipe. Martha Stewart may give certain level of instructions, and maybe, some other chef gives the narrative in another way. So that's what we call a thin copyright, because the majority of the information is fact-based. The point is, copyright protection of the 3 major disciplines, patent, trademark, and copyright, is the most inexpensive to seek. But you do need that registration if you want to get into court and enforce your rights. Work for hire. This is the most important part for all of you. This is the most misunderstood aspect of the Copyright Act. Work for hire applies to the employer-employee relationship. And most people misapply it to vendor relationships. An outside contractor is not a work for hire relationship. So if you have employees, you should have some sort of an employment agreement that says that everything that your employees develop in the scope of their employment with you belongs to you. Now, that's a function of law, but it's a good practice to have that documented in an employment agreement. It doesn't matter if what they do is developed during off hours. So if someone has a side hustle and they develop IP in their off hours, it doesn't matter. You still own it. The company still owns it, not you personally. I recommend, if you're a nerd like me and you're interested in these issues, read this fascinating book, which is hyperlinked here, called You Don't Own Me. It's a fascinating look behind the scenes between Mattel and Bratz, and a designer that worked at Mattel and took a leave of absence and felt that he was being stifled and developed a new type of doll. He basically was the designer of the Bratz doll, and basically started the company at Bratz with other people, and a 10-year lawsuit that ensued, and Mattel just buried him. If you love legal stuff and corporate espionage, it's an amazing book. It reads like a nighttime soap opera. It is absolutely fascinating. If you hire software engineers or other inventor type people, make sure you're having them identify any patents that they own prior to coming to work for you. They typically will want to exempt them from any type of a work for hire agreement because it's their prior invention and they won't want it wrapped into their employment agreement. Now, why am I bringing this up? Because working with vendors, any creative vendors, is so critically important, because copyright law is an interesting area of the law, because as a function of law, the copyright vests with the creative author of the work, not the person who pays for it. This is also a very misunderstood area of the law. So for instance, if my logo here in the corner, this blue and gray KLO logo icon, the person who developed that for me, they owned that until the point in time when I asked them to assign their rights in that logo to me. As a function of copyright law, they, as the creator of that logo, owned the copyright. So all of your graphic designers, all of your copywriters for your website, all of your computer programmers, all of the photographers that you are hiring, they own the copyright unless and until they choose in writing, and you should demand this, to assign their copyrights to your company. There should be a standard clause in all of your agreements with these vendors that assigns the IP rights, especially copyright, because of this wacky way the law works, from the creator, the vendor, and all of their employees and subcontractors to the company. And typically we say upon payment of all undisputed amounts. That must be in writing to assign the copyright. I have an issue right now with one of my clients where the vendor is claiming their terms of service on their website governs. Well, why doesn't it govern? It's not a writing signed by anyone by the vendor. That's the issue. Your goal is to make sure that all of the company's IP is owned by and assigned to your company. Now, often these agreements are structured as work for hire agreements. It's not correct, but I don't care as long as there's an assignment clause that assigns the copyright over from the vendor to you. So I have a couple of scenarios to bring this into focus for you. Let's take a look at them. So one of your business groups has a logo developed for your company. Let's say a friend who's not an employee is asked to develop the logo with the intention that it will belong to the company. The friend says, yeah, of course, the company can have it. That person is paid by the company. A check is cut from the company to that creative. Let's assume there's no other paperwork or contract. Who owns the logo? The designer does. Why? There was no writing signed by the creative. You see? Let's look at the second scenario. A content writer is hired to develop all of the copy for the website for your company. Fantastic. The content writer gives you a contract that says upon payment in full, she will transfer all rights to the copy to your company. Sounds fantastic, right? Who owns the website copy? Well, sorry, this one's a little bit of a trick. It depends. As long as the content writer signs the document, it's a valid assignment. And so that was one fact I left out here, and that's what I wanted you to pick up on. Other than that, this is perfect as long as she signs it. As the creator, she has to sign, and that's the detail I wanted you to pick up on here. Okay, fair use. This is thrown out a lot. I know we're running short on time. I really want to get to your questions. Fair use is a defense to an admission of copyright infringement. It's not a right that a copyright owner has. It's a defense. Any commercial use is likely not to be fair use. But just because something is available on the internet doesn't mean it can be copied or used without permission. Please, please, please always seek permission, a license, or an assignment before you allow your business teams to use a photo or any other creative work. Don't allow use if they don't have written permission. Photographs, they're the easiest thing to register for copyright and the thing that most cease and desist letters are sent on. There's an entire cottage industry set up by law firms to sue infringers of photographs. Please don't use cheap licensing sites for photographs. A license for commercial use doesn't cost $19 or $29. It depends on the territory, the impressions, the amount of time the photograph's going to be used. And I promise you, the more successful you become, the more of a target you will be. Statutory damages range between $750,000 and $30,000 per work, and it can be $150,000 if the infringement is willful. So the third scenario that I skipped over, which you can read in the materials, was based on an actual case I negotiated when I was in-house. I received a demand letter for $3 million my third week on the job, and thankfully I was able to settle it, but we were absolutely guilty. Our business team was guilty. So, and it was all over photographs and being used outside of a agreed upon license. So please monitor this if you're using photographs in your business. There's a few war stories here. Shai, I don't know if we should get into these or if we should, just go to questions. I don't know how many questions there are. I want to be respectful of everyone's time. I so appreciate how many people have stayed till the end, but I leave it up to you.
Yeah, I think there's a bunch of questions. So maybe one, can we pick the best war story and then we'll questions?
Yeah. So I think, this pure spectrum case is very similar to what I just discussed. The Clint Eastwood case I want to talk about because it's really interesting. It involves the CBD industry, which I think has seen a lot of infringement. So this happened late last year. Clint Eastwood sued 40 CBD companies for violating his rights of publicity. Rights of publicity are state right, but it involves name, image, likeness, persona. And so they were using his name and his image without his permission, and they were using that to promote the sale of a CBD product. So think of it like an endorsement. He was not endorsing these products. Now, obviously, he has the ability to sue. He has an endless war chest. It also was a trademark infringement case for using his name, which is trademarked Clint Eastwood, in connection with the goods. So his name is registered for entertainment services. So the court ruled in his favor. They ordered payments of $6.1 million in damages. It was actual damages. This was not punitive, of $6 million. And then the rest was attorney's fees. The court awarded this for the violation of his rights of publicity only. They did not reach a decision on trademark infringement. There was a case many years ago involving Katherine Heigl with Duane Reade Drugs, where they had snapped a picture of her in her everyday life walking out of a Duane Reade drugstore, and they posted that to social media. That's the more likely scenario I think you're likely to encounter in your everyday life. That case didn't go to decision, but it settled reportedly for somewhere in the $6 to $10 million range. Katherine Heigl, if you don't know, is incredibly litigious, and with good reason, over her persona. What you have to understand is celebrities have a shelf life, right? Some longer than others, in the case of Clint Eastwood, and they make their money over selling their rights of publicity, their ability to endorse products. So my cautionary tale to you is be very careful when your business teams want to use any persona or celebrity to promote what you're selling, because that is a violation of rights of publicity, and it's straight up trademark infringement. The better way to do that, if you observe a celebrity using your goods or services in their everyday life, is it's a wonderful invitation to reach out to their team and ask them if they're interested in endorsing your products. So I want to thank you all. I want to just end before we get to questions with 5 minutes about trademark abilities, in case this is an area you're interested in learning more about. We've just updated our course. We now have brand new material. It's been about 2.5 years since I recorded the course. We have a 12-hour CLE certified course. We provide turnkey, comprehensive training, and we walk step by step through the entire prosecution process. We start with searching. We walk through the application process, screen by screen at the USPTO, how to respond to major issues of office actions and post-registration issues. We have an entire library of client communication templates and substantive templates. So our course is value priced at $24.95. We're offering a special for everyone who has attended the program today. It's a buy one, get one half off for in-house counsel. Now it's an individual license, so you're not buying it for your company. Everyone has to be registered individually. That's outlined in our terms of service. But you can purchase the course for $1871.25 is what it works out to if you do the buy one, get one half off. If you're a solo in-house person, you're interested in learning more about trademarks, we're offering $500 off, which brings it to $19.95. And I don't know if there's any law firm practitioners who are logged in today, but we're offering a 10% savings for law firm practitioners with the coupon code TMA IHC10. If you're an in-house person, you want to take advantage of any of our special offers, you need to email us at hello@trademarkabilities.com and let us know how many people you want to enroll, their names and your company name. And this offer is valid for 2 weeks, no exceptions. And once you email us, we'll send you back details on how you can enroll and pay us and get started. So I really can't thank you enough. And I hope you found it valuable. As Shai mentioned, I do post a lot on LinkedIn, so please follow me. My contact information is there if I can ever assist you. And with that, Shai, I'm going to turn it over to you to feed me some questions, which I would love to answer.
I just want to say thank you again for your amazing presentation. All the knowledge you shared, it was wonderful. I learned a lot. I know the audience learned a ton as well. We have a bunch of great questions. So I'll start with a few. What's the thinking with using outside counsel to send cease and desist letters? Do you feel it carries more weight, or does it require, significant expertise, or staying up to date on the most latest developments that any in-house counsel can do?
So I think a couple of things. I think that there can be an advantage to having in-house counsel send the cease and desist letter. My caution would be to just make sure that the letter is warranted. And I think unless you have expertise in the area, you just want to gut check it with outside trademark counsel before you send the letter, just to make sure that you're not walking into a hornet's nest. So absolutely, you're more than qualified to send the letter. Just make sure that you're sending it, you have the right basis for sending it. So many of these letters these days end up on social media, being posted to social media. And that's the worst thing that you, that's a nightmare come true, right? Because then it becomes a PR nightmare. So, I mean, if you feel confident that you've got the right basis, you don't want it to end up on social media, and you sure don't want to be served with a DJ action as a response.
As far as like assignment IP, this is a lot of people were wondering, do you think that copyright or any IP assignment should be made upon payment or upon creation? I know some practitioners prefer to have it assigned at creation. That way, if there's a payment issue, the vendor has breach of contract remedies, but not IP infringement. Would you say that's too aggressive, or what's like the best, posture to take?
Payment's a best practice. No vendor is going to agree to upon creation.
Or, well, no creative you're saying is going to?
Right. Yeah.
Okay. So I mean, is it too aggressive for a company to ask their creative person to, assign upon creation, and then
you can do it? They won't sign it though.
So in your experience, payment is like the market standard.
Yes, it's a best practice. I think you're going to look. There's not a good relationship between legal and creative agencies to begin with, and you're going to further ostracize your agencies. You can certainly make that request, but they hate the assignment anyway. Any reputable agency should have assignment language in their agreements anyway, in their master services agency, or it can even be informal, but they want to be paid before they assign their rights, and there's nothing wrong with that.
Got it. Next question regarding to fair use. So there's a couple. Does fair use cover use of pictures and photos and training and seminars and like other teaching conferences? Like you put in some trademarks of of famous trademarks. I guess fair use of you to use those trademarks.
So it depends. There's an educational. You can't just grab photos off the internet. All of my photos were Creative Commons licensed photos, or my other photos were from publicly sourced court documents. But there is an educational exception to fair use. The caution there is you have to be careful. Is it truly an educational exception, or do you have an educational business? And that's the other thing that I counsel my clients on, who also have an educational business like my business. My second business is an educational business, and its primary pursuit is commercial use. So it's a hard one. You need to definitely look at there are exceptions to fair use. Again, the point is that fair use is a defense to infringement. And so you have to be prepared. There's no magic wand. It's a balancing test. And so you have to be prepared to litigate it. There's no magic wand with fair use. And I think that's the thing that's most misunderstood about fair use. It's not a right, it's a defense. And if you're wrong, are you prepared to go to court and litigate it?
Got it. What is the correct form for the copyright symbol? Is it the C in a circle, or should you say copyright? Should you spell out copyright? Is there another form that we're not aware of? Is it
so you can check my website at klolegal.com in the FAQs. I have a standard copyright attribution statement. But again, it depends. You can also check the bottom of my KLO website. because some of my content is used under license or so. Yes, but we cover that in our FAQ. So you use the copyright symbol. It's copyright circle C. You can reverse those if you want. There's no real magic. The first year of publication, the owner of the assets, it should be the company, all rights reserved. And then we use a lot of our content, our photos is under license. So that's how we do our copyright notice. But in our FAQs, we have a general, how do I properly use the copyright symbol? Copyright notice, first publication year, legal name of copyright owner, period, all rights reserved.
Got it. Awesome. Thank you for sharing. Super helpful. I had a question come in. Where is the search for trademarks begin? Is it on tests? Yes,
that's where you start a preliminary search. There are also software, trademark software providers, but yes, you can absolutely do that in tests. It's free.
Got it. And so like, let's say you do a trademark search and then, you don't see anything come up. Still, you need, are you in the—
You definitely didn't do it right then.
Or maybe you found a good—
It's possible, but again, it's negative. So if you found nothing, you should absolutely do a full search. That's just tests. You haven't searched the states. You haven't searched common law.
Gotcha.
Yeah, no, full search then that means it's a terrific candidate for a full search.
Okay, fair enough. Is there any relief for a frivolous challenge to a trademark suit?
So I don't like the word frivolous. I don't know what frivolous means. So everyone thinks every lawsuit is frivolous. I would defend it vigorously. There are sanctions, but sanctions to me is different. The reason I phrase it in that way, Shai, is because trademark owners have an affirmative duty to police their marks. So what one person thinks is frivolous, another person thinks is their duty to defend their mark. So, I'm pretty outspoken on my LinkedIn feed regarding cases that I think are pretty ridiculous. But again, the person who filed the lawsuit thought it was really, really important. And, so I think there are just a lot of, I see a lot of small business owners just starting out and they complain and they whine on social media about how they're being bullied. No, they're not being bullied. It's just usually they don't understand that a mark is famous. They don't understand what's at risk, or they don't understand that a company is just really trying to protect their investment. So, yeah.
Next question. Let's say you're a for-profit company and you have a not-profit arm. Can either company use the other's trademarks interchangeably? Do they need anything in writing?
A license agreement.
Okay.
A license agreement.
If there's no license agreement?
No.
So license agreement.
They're different companies. So that is definitely a situation where a license agreement would be needed. If you're talking separate entities, there has to be a license agreement.
Got it. Next, and I think we'll wrap up with this one. There was a nice little conversation in the chat about Kleenex and like the proper use of Kleenex. So I'll read the whole thing and then we can chat about it.
Sure.
An example of misuse is overuse the same as misuse. And then somebody said regarding Kleenex, I believe that overuse isn't the problem, rather it would be improper overuse. Like proper, please pass me a Kleenex brand tissue. Improper, please pass me a Kleenex. Kleenex needs to be used as an adjective, I believe.
So I love that example. I'm so glad it was brought up. So the person who said Kleenex brand is correct, because if you actually inspect the packaging of Kleenex, all over their packaging, it says Kleenex brand tissues. So They are properly protecting their mark. The fact that people are asking for a Kleenex when perhaps they receive a Puffs or a Target brand or a Walmart brand, that's something different. A little known fact is that Coca-Cola initiated a lawsuit against a number of restaurants. I don't remember the year. This was a long time ago, because you'll think about it now as I'm telling the story. When you sit down in a restaurant, if you actually prefer Coke, which I do, I cannot stand Pepsi. I don't drink soda anymore. But when you ask for a Diet Coke or for a Coke and your server says, we only have Pepsi, is that okay? Are you thinking about it with me? Because you know it happens. The reason that statement happens is because many years ago, Coke sued. Because many years ago, right, it was probably like 20 some years ago, when you went into a restaurant and said, I'll have a Coke, and you were just given a Pepsi, people like me knew the difference, and you'd be like, this isn't what I ordered. This is not a Coke. And they'd be like, oh yeah, I know, we just have Pepsi. Well, guess what? That's trademark infringement, because that's not what you asked for. Now, for the small percent of the population who could care less, they don't care. They say, oh, we only have Pepsi. So, okay, yeah, I don't care, whatever. Just give me whatever you have. But Coke sued, and rightfully so, because to pass off a Pepsi as a Coke, not the same thing. So very interesting conversation. I mean, what I usually get asked about when I talk about genericness and misuse is Google. I can't respond to that because Google has been sued for genericness, and I don't know why the court hasn't ruled that that mark is generic, because I think it is. I think Google even uses their mark generically, and everyone says, oh yeah, I Googled it. Oh yeah, Google it. I mean, we trademark attorneys try to use the mark properly, but it's hard. Good question on Kleenex.
All right. Well, I think that's about, I don't know, an hour and 45 minutes of trademarks.
If there are any other questions we didn't get to, feel free to email them to me. I'm happy to answer them offline, but those are good ones. Thank you, everyone, for the great questions.
Yeah, thanks to everybody for attending, for sticking around. Still have 130 odd people, who stayed for the whole thing. So that's wonderful. Thanks for everybody for attending. Like I said before, we have, a great event coming up on Thursday, another one next Thursday, and obviously many more on the horizon. Thank you, Stacey, for delivering this fantastic presentation. We all really, really appreciate it. And, again, Trademarkabilities, I posted the link several times. The recording will be ready in about, a week or two, so stay tuned. And then, please follow Stacey on LinkedIn and email her if you have any questions. And if anything else, reach out to me, and I'm happy to help. So we will.
Likewise.
Yes. Thanks again, Stacey.
Thank you so much for having me.
It was our pleasure. Thanks everybody for attending, and we'll wrap up here. Have a great rest of your days, and we'll be back on Thursday. So talk soon. Take care.